All right, you guys saw my video from earlier. So all the announcements I think are taken care of. We have an exam on Monday and it will get posted on Monday morning, and you'll have a week to take that just like you did your quiz. Email me with any questions, and I'm gonna go ahead and dig into what's chapter 6 for me. I think chapters are messed up for some folks, so you have a few different versions of our textbook. It probably is chapter 6 for everybody now, the struggle for equal rights. So the book opens talking about what happens when a racial majority becomes a minority. In the 2016 election cycle, it was really a time for coming out of the shadows. Trump is showing that an America First idea works electorally. It was overtly racist, alt-right ideology that opposed immigration, multiculturalism, and the classic democratic values that undergird the American political system. His remarks encouraged bigotry. He said the problem this country has is being politically correct. Which ignited and gave hope to a different side of American politics. He made a deliberate appeal to voters' sense of racial and gender grievances, and a lot of people felt liberated by this. Folks without mainstream views have felt that their ideas have been taken out of the darkness. Yet mainstream America is becoming more diverse, and groups that white nationalists disdain are slowly becoming the majority. They were vocal supporters of Trump, but they're a small group. Lots of Trump supporters are rural males without college educations who would never think of themselves as racist, but maybe recognize the white privilege that they were born with only in its absence as they compete for their dwindling share of the American dream. They've been told what their birthright is, and they believe they are, in fact, targets of racist behavior. Trump's use of language was key to invoke nostalgia for an America long gone. Make America great again. He used again and back and spoke to people who think America isn't as great as it once was. This, of course, was in 2016. It was more of a cultural nostalgia. Great for some, but not for others. Women and African Americans didn't have it great in days of yore. Racism has always been a permanent thread in American political fabric and may always be, but there are some new undeniable facts. Our racial landscape is changing. Whites are a diminishing racial group, and people of color are growing in numbers. There are nearly 11 million undocumented workers that live and work in the United States, and there's no easy way to repatriate them. Muslim Americans are deeply integrated into the communities. There was a black man, President Obama, who was elected to and served 2 terms in the White House and left with a significant majority approving of the job that he had done in the White House. But a newly elected Republican government promised to dismantle what he did. What's at stake when a demographic group that is accustomed to being privileged starts to lose its majority status? What's at stake in civil rights politics in general? We're going to dive into that a little bit. When you consider where we started, progress towards equality in the United States can look pretty impressive. Look at racial equality. Just over 60 years ago, it was illegal for most blacks and whites to attend the same schools in the South, or use the same swimming pools or water fountains, but this is a distant memory for most of us. Exactly 40 years after MLK Jr. said he dreamed of a day where a child would be judged by his character and not by the color of his skin, Barack Obama accepted the Democratic Party's nomination for presidency, which he won twice. But there also only remains few blacks in an unelected office. USA Today said in 2002, so things have changed, but not that much. If the United States Senate and National Governors Association were private clubs, their membership rosters would be a scandal. They're virtually lily white, and not much has changed. Civil rights are citizenship rights. We talked a little bit about this last class. Citizenship rights guaranteed to the people primarily in the 13th, 14th, 15th, 19th, and 26th Amendments, and protected by the government. Formally granting a civil right doesn't necessarily bring about a speedy change in social and economic status. This also includes Native Americans, Hispanics, Asian Americans, all have faced unequal treatment in the legal system, job market, and schools. Women, half the population, have long struggled to gain economic parity with men. Sexual orientation, age, physical ability, citizenship status, these are also groups that have been denied rights. Intersectionality, this is the interdependent discrimination and oppression that results when an individual is a member of more than one oppressed minority group. For example, you're black, female, and poor. The United States is haunted by traditions of unequal treatment and intolerance that we can't entirely shake. And as we pay attention to the rights of those haunted by these traditions, this is seen by some white people as diminishing their own rights. Americans expect that the law should treat people equally, But laws by nature must treat some people differently. Laws discriminate between those who abide by society's rules and those who don't, but they can also treat criminals differently once they're convicted. In all but 2 states, felons are denied the right to vote for some length of time, and in some states permanently. In fact, I clerked for a judge after I graduated from law school, and I'll never forget, this man was pleading his case in front of us before he went to jail, and he said, "Please, sir, don't take away my right to vote." And that just really stuck with me. When the law can treat people differently, there are 3 tiers of legal classifications. The first tier is the classification of people that are so rarely constitutional that they are immediately suspect. Suspect classifications require the government to have a compelling state interest for treating people differently. Race is a suspect classification. A classification such as race for which any discriminatory law must be justified by a compelling state interest. The court subjected this to a heightened standard of review called strict scrutiny. Again, we're delving into law school here, but stick with me. This is a heightened standard of review used by the Supreme Court to address the constitutionality of laws that limit some freedoms or make a suspect classification. Courts look carefully at the law and the government interest involved. The catch is that while laws discriminate against a suspect class are examined carefully, so are laws that discriminate in their favor. Laws that deprived people of fundamental religious rights were once required to pass the compelling state interest test. At that time, religion was also viewed as a suspect class. The second category, the classifications that Supreme Court views as less potentially dangerous to fall into this middle tier. This is called quasi-suspect. May or may not be subject to legitimate grounds for treating people differently. So it's subject to an intermediate standard of review. This is a standard of review used by the court to evaluate laws that make a quasi-suspect classification. The Supreme Court looks to see if the law requiring different treatment of people bears a substantial relationship to an important state interest. The important state interest test is not as hard to meet as a compelling interest test. Laws that treat women differently than men fall into this category. So 3, least scrutinized category is for the non-suspect class. This is subject to the minimum rationality test, which is a standard of reviews used by the court to evaluate laws that make a non-suspect classification. The Supreme Court asked whether the government had a rational basis for making a law that treats a given class of people differently. Laws that discriminate based on age, like a curfew for younger people, economic level, like a higher tax rate for those in certain income brackets. They don't need to stem from a compelling or important government interest. The government just needs to have a rational basis for making the law. This is fairly easy for the legislature to show. So all 3 of these groups feel discriminated against. They all want the Supreme Court to view them as a suspect class, so they'll be a protected group. The civil rights in the 14th Amendment might protect them anyway, but if they're designated as a suspect class, the Supreme Court is unlikely to permit any laws to treat them differently. So gaining this status is crucial in the struggle for equal rights. And it wasn't until the 1950s that race finally became a suspect class. Women's groups have failed to convince the Supreme Court to amend the Constitution to make gender a suspect classification. LGBT communities struggled to get the Supreme Court to consider them a quasi-suspect category and didn't get a specific standard of review when it didn't specify a standard of review when it struck down the Defense of Marriage Act in 2013. Why do we deny rights? This is usually explained by creating a narrative focused on the characteristic of the group. We would say maybe a group is not civilized or does not recognize the true God. People are compelled to justify poor treatment by blaming the group they are treating poorly. People often deny the rights of others because rights are power. To deny a right is to have power over someone and how they will live in their lives and force them to conform to their will. Slaves were compelled to work for a master's profit. Women denied the rights to divorce their husbands. Native Americans were forcibly removed from their land so those lands could be developed. When we deny someone a right, it keeps them submissive and dependent. When someone finds a voice and can effectively demand rights, these laws change and they can soon leave subservience behind. People also deny rights to isolate categories of people, like recent immigrants who don't speak English, maybe a homosexual whose lifestyle seems threatening, somebody who has an unfamiliar religious belief. This helps a group build a narrative that defines who they are, who their relevant community is, and who they're not. And it helps these communities believe that they, with their culture, values, and beliefs, are superior to people who are different, which promotes cohesion and builds loyalty to people who are like us and intensifies dislike and hostility towards those who are not our kind. This is only a small step away from there to believing that people outside the community don't really deserve the same rights as those superior people within. Disputes often arise because we think equal must mean identical or the same, thus making equality threatening to the American value system, which prizes freedom to be different and unique. We rely on the government to guarantee fair and equal treatment, which is a procedural value, like we talked about earlier, rather than to manipulate fair and equal outcomes. We want equal opportunities, not equal outcomes. Procedural instead of substantive. We want the government to treat everyone the same, and we want people to be free to be different, but we don't want government to treat people differently in order to make them equal at the end. Does that make sense? When laws are changed, this is a procedural solution, but substantive action may still be necessary to ensure the equal treatment in the future. The narratives of white supremacy and Black inferiority were told to numb the sensibilities of European Americans. This has been almost as dangerous as slavery itself and has lived on in the American psyche and in politics much longer than the practice that they justified. Racism is the institutionalized power inequalities in society based on the perception of racial differences. This is not a Southern problem or a Black problem. It is an American problem and something that we have not yet eradicated from national culture, as events over the last year have shown us. Would it be a good thing or a bad thing if we treated all people exactly the same? What would that look like? Something to think about. At the time of the Civil War, there were almost 4 million slaves in the South and nearly 500,000 free Blacks in the rest of the country. But even if slavery was illegal, Blacks didn't enjoy the full right of citizenship. Dred Scott versus Stanford in 1857 was when the Supreme Court ruled that Blacks can't be citizens because the founders had not considered them citizens when the Constitution was written. Abolitionists were a coalition of free Blacks and Northern whites that worked to end slavery prior to the Civil War. They tried strategies. They put pressure on the Republican Party to take a stand on political equality, and they persuaded 3 legislatures, Iowa, Wisconsin, and New York, to hold a statewide vote on Black suffrage between 1857 and 1860. But all 3 lost votes by large margins, even in the North. Public opinion did not favor Blacks. The Emancipation Proclamation after the Civil War, Lincoln was not simply taking a moral stand here. He was trying to use economic pressure to keep the country intact. This didn't free all slaves, only those in states that rebelled against the Union. The 13th Amendment banned slavery, which was passed by Congress in 1865, and it was a huge blow to Southern white power. But the South retaliated to ensure their dominance with Black codes, which were a series of laws in the post-Civil War South designed to restrict the rights of former slaves before the passage of the 14th and 15th Amendment. It essentially sought to keep Blacks in subservient economic and political positions by legally restricting most of their freedoms, voting, property owning, education, that they gained by becoming a citizen. Reconstruction was the period following the Civil War during which the federal government took action to rebuild the South. The 14th Amendment was passed in order to make Black codes unconstitutional. It guaranteed that all people born or naturalized in the United States the right of citizenship and said that no state can take this away. The 15th Amendment was effectively extending the right to vote to all adult males. That was in 1879. Southern life began to change. Blacks voted, some were elected to local offices, and this cemented Republican dominance with their support. But Southern whites responded with violence. The KKK terrorized Blacks. They lynched, arson, assaults, beating. It made it scary to associate with Republicans at the time. Southerners set about the business of stripping Blacks of their newfound political power. Disenfranchising Blacks became easy to accomplish. The 15th Amendment said the right to vote couldn't be denied based on the basis of race, color, or previous condition of servitude, so the Democrats who controlled the South set out to deny it in other ways. They levied poll taxes, which was a tax levied as a qualification for voting. It took away the right to vote for most Blacks who were too poor to pay to vote. Literacy tests requiring reading or comprehension skills as a qualification for voting. Most Blacks were denied education, so they couldn't read. But if they could, a registrar would administer the test unfairly. Jim Crow laws, the Southern laws that were designed to circumvent the 13th, 14th, and 15th Amendment, and to deny Blacks any rights based on anything other than race, proved to be very effective. Jim Crow was a pejorative expression meaning Negro. By 1910, the registration of Black voters had dropped dramatically, and the registration of poor, illiterate whites had also fallen. Southern Democrats were back in charge, and this eliminated the possibility of competition. Segregation was the practice and policy of separating races. There were separate facilities for Blacks and whites for leisure, business, travel, education. Facilities for whites were cleaner, newer, and more comfortable. In 1875, there was a Civil Rights Act that guaranteed all people, regardless of race, full and equal accommodation. But it was struck down by the Supreme Court, arguing that the 14th Amendment can restrict the behavior of the states, not private individuals. In Plessy versus Ferguson, the Supreme Court case, this was a Supreme Court case that established the constitutional of the principle separate but equal. At the time, folks embraced separate, but they forgot the equal part of the ruling, thinking that the Supreme Court had approved segregated facilities. The National Association for the Advancement of Colored People, NAACP, was an interest group founded in 1910 to promote civil rights for African Americans. They were able to develop a strategy over time that was finally the undoing of Jim Crow, and they supported FDR's New Deal. Wanting to woo black voters from the Republican Party, Democrats wanted to influence the blacks as much as they dared without alienating the powerful Southern Democratic congressman. Thurgood Marshall was a young lawyer with the NAACP who decided to launch this attack in education. There was a poor quality of black education in the South that was reinforcing beliefs about black inferiority. So instead of immediately targeting elementary schools, which would have terrified whites, they started with law schools, which would fly under the radar of most. There were no black law schools, and the Supreme Court knew well about this, so this was masterful. Justices had all had a shared experience of law school, and it was almost impossible for them to refute arguments that a separate education was unequal. Brown versus the Board of Education of Topeka. Brown, we just call it Brown versus Board, was the Supreme Court case that rejected the idea that separate could be equal in education. The NAACP used law school cases to emphasize the intangible aspects of education, including how black students felt when made to go to a separate school. They cited sociological evidence of low self-esteem of black school children that argued that it resulted from a system that made black children feel inferior by treating them differently. Supreme Court ruled in favor of Linda Brown and the black students, and they didn't explicitly overturn Plessy to keep the South from erupting in violent protest, but they held that separate, by its very definition, could never be equal because it was the separation itself that made black children feel unequal. Segregation in education was inherently unconstitutional. This didn't bring instant relief to the Southern school system, though. The most public and blatant attempt to avoid the compliance happened in Little Rock, Arkansas in 1957. The governor posted the National Guard at a local high school to prevent the attendance of 9 black children. Rioting white parents showed faces of bigotry on the nightly news. It took 1,000 troops sent in by Eisenhower to guarantee the safe passage of 9 black students through the mob of angry white parents who threatened to lynch them rather than to enter the school, which proved to be a catalyst for the civil rights movement that would change the whole country. Rosa Parks sat on a bus in Alabama in 1955 and refused to yield her seat to a white passenger as the law required, so she was arrested and sent to jail. A boycott is the refusal to buy certain goods or services as a way to protest policy or force political reform. And so local groups in the black community boycotted the Montgomery bus system, and they made up most of the bus riders. But it continued for over a year before the Supreme Court affirmed a lower court that the law is unconstitutional. Separate bus accommodations were not equal. Okay, so 2 kinds of discrimination we have. De jure discrimination, which means discrimination by law, discrimination that arises from or supported by the law. This is what most blacks in the South faced, especially in rural areas where blacks and whites worked and lived side by side, so they had to use separate facilities because the law said so. And then there's de facto discrimination in fact, that is the result not of law, but of tradition and habit. This is a lot more difficult to eliminate. Segregation in the North was this way because blacks and whites didn't live and work in the same places. It wasn't laws that kept them apart, but past discrimination. Tradition, customs, economic status. It's hard to remedy this because there's no laws to change. Martin Luther King Jr. became known for his nonviolent approach to political protest. This was important not just for the practices that it challenged directly, but for the pressure it brought to bear on elected officials and the effect it had on public opinion. The Voting Rights Act of 1965 disallowed discriminatory tests like literacy tests and provided for federal examiners to register voters through most of the South. The Supreme Court backed this up. The 24th Amendment outlawed poll taxes in federal elections. Political and educational advances didn't translate to substantial economic gains, though. Blacks remained at the bottom of the economical hierarchy. Black Muslims, led by Malcolm X, Black Panthers, the Student Nonviolent Coordinating Committee, all demanded Black power and radical change. They rejected the Martin Luther King Jr. peaceful attempt to bring about gradual change. There was something called busing. This was trying to achieve racial balance in schools by transporting students to schools across neighborhood boundaries. Black students would be bused to schools in white neighborhoods and vice versa. Parents who moved to better neighborhoods to send their kids to good schools were unhappy. The Supreme Court endorsed this as a remedy for segregated schools, but ruled 3 years later that busing plans couldn't merge inner city and suburban districts unless officials could prove that the district lines had been drawn in a racially discriminating manner. Some early efforts at affirmative action. Affirmative action, of course, is a policy of creating opportunities for a member of certain groups as a substantive remedy for past discrimination. For example, if a firm had no Black employees, it wasn't enough not to have a policy against hiring them. The firm actually had to actively recruit and hire Blacks, which counted in universities as well. The Supreme Court affirmed this decision, though it took issue occasionally with specific implementations. The end result of affirmative action seems attractive, but the means to get there, treating people differently, seems inherently unfair in the American value system. Do you guys agree or disagree with that? In 2008, obviously, Obama was elected and served 2 terms as president. His election promised to usher in much more relaxed attitude toward race, but somebody has commented on Trump's election as what's called a white lash to Obama's presidency. So we've had some political gains and losses. Affirmative action today can't really be about racism and bigotry, but 2 images of what America ought to be. One side has a vision of America whose discriminatory past is past, and whose job today is to treat all citizens the same, providing a lower set of standards. It's not fair to anybody. People tend to perform at the level of competition. When the bar is raised, we rise to that occasion. That's what Black students will do in a society that has equal standards for all. That is according to Ward Connerly, an African-American businessman. The other side will say that those who argue that affirmative action programs have made a real difference in equalizing chances in society, though they are meant to be temporary, they say their work is not yet done. African Americans, of course, are not the only ones who have been denied rights on the basis of race and ethnicity. Native Americans, of course. The relationship between the original inhabitants of this continent and colonists and their government has been difficult. There are lingering effects of that today. Indians they actually have a different legal classification. They are citizens of tribes as well as citizens in the United States with rights coming from each. Reservations are separate legal entities under the federal government. Since the 1980s, they have parlayed their status as semi-sovereign nations into a foundation for economic prosperity. Like if a state allows any gambling at all, then an Indian reservation in that state may allow all sorts of gambling, subject only to regulations from the Bureau of Indian Affairs, which is under the Department of Interior. They may now have giant casinos and money pouring into their coffers. But some Indians see gambling as their economic salvation and others see it as spiritually ruinous. Another diverse group with a history of discrimination is Hispanic Americans. They face peculiar challenges of their own. They have a language barrier oftentimes, a political reaction to immigration there, but they are the largest minority group in the United States. There have been English-only movements to make English the official language of the United States, and this has appeared on ballots and official documents. This is clearly about more than language. It's about a national and cultural identity, which is a struggle to lay claim over the voice of America. What about Asian Americans? They're identifiable by their appearance, and so it makes them harder for them to assimilate into a European American population. The unusual feature of Asian Americans is their overall academic success and economic prosperity. They stand in an odd relation to affirmative action because they are often admitted to high-level elite schools, and the policies tend to harm them because there are so many that are well qualified. They'd be admitted even if race were not taken into account. So policies that pit minority groups against each other in this way don't promote solidarity and community among them. Voter turnout should be quite high in this group because voter turnout usually corresponds with education and income, but Asian Americans turnout is typically the lowest in the nation. They tend to register as independents, and sometimes they just don't vote because nobody asks them to. What about rights based denied on the basis of gender. Women's struggle for equal rights has perhaps been the most peculiar because women were never outside the system in the way that racial and ethnic groups were. But women's work was in the home, and white women were to be good, pure, and chaste, and too good and pure to deal with the sordid world outside. Women were not exactly slaves, but not much different. When a woman married, she merged her legal identity with her husband, and she could no longer be a party to a contract, bring a lawsuit, inherit property, etc. She couldn't gain children in a case of divorce or initiate divorce. And if her husband was not a U.S. citizen, she lost her citizenship. Neither married nor unmarried women could vote. Unmarried women didn't have a lot of opportunities, and most worked in domestic service and later in the textile industry. And most married women didn't work outside the home. Women really struggled for rights, and they targeted states that were sympathetic toward them and gradually began gaining enough political clout that their demands were listened to on a national level. In 1919, the Susan B. Anthony Amendment granting women the right to vote was reintroduced to Congress by President Woodrow Wilson and finally passed. In 1920, Tennessee became the 36th state to ratify the 19th Amendment, and women finally had the right to vote. That was just 100 years ago, guys. Most women, though, lacked money, political contacts, and experience to get involved in politics. And politically active women were ostracized and accused of being unfeminine, making political involvement too costly to many. So the 19th Amendment gave women the right to vote, but it didn't ensure constitutional protection against discrimination. The Equal Rights Amendment was a constitutional amendment passed by Congress but has never been ratified that would have banned discrimination on the basis of power. The Supreme Court has begun striking down laws that treat women differently by using equal protection from the 14th Amendment. This takes it as a sign that the Equal Rights Amendment was unnecessary. Is it possible to have too much equality? What do we think? This is where I make you raise your hands if we were a person. Some laws that treat men and women differently have been upheld by the Supreme Court, like statutory rape laws, which are laws that require only males to be drafted. But still, there's striking discrimination in the workplace, and the ability to seek remedies are limited by law. Sexual harassment, the unwelcome sexual speech or behavior that creates a hostile work environment. The Me Too movement, high rise in the number of cases and discrimination reported by women, by pregnant women. A lot of pregnant women say their bosses have reacted negatively to their pregnancies. In 2016, though, we had our first woman presidential candidate, and obviously now we have our first woman vice president. There are other rights denied on other bases as well. Sexual orientation. Until 2011, gays couldn't serve openly in the military. Age. Younger people can't vote, but older people defend their interests very effectively. Voter participation rates rise with age, and older Americans are typically well organized politically. Disability. The 1990 Americans with Disability Act was modeled on the civil rights legislation that empowers racial and gender groups, and it protects the rights of the disabled and guarantees protection from the bias of employment. Should non-citizens have the same rights as citizens? The Constitution gives them most of the same rights except for the right to vote. Can you think of other groups that face discrimination? A lot of things. So civil rights and citizens and the civil rights. So the pluralist model of democracy best describes the actions that citizens have taken to gain the government's protection of civil rights, and emphasizes the way citizens can increase their individual power by organizing into groups. The question I really want you to ponder for this is, would it be a good thing or a bad thing if we treated all people exactly the same? What would it look like? Is it possible to have too much equality? Those are kind of our takeaways from today's lecture. Go study your notes. Chapters 1 through 6 will be on next week's exam. Will be very similar to what we just had on our quiz last week. Please email me if you have any questions. Thanks.